Good afternoon, guys. Welcome to the webinar. What we're going to do, because of the switch over from generators to ESCOM and vice versa, we'll give 5 minutes chance for this to occur. So we'll commence at 12:05. Thank you. See you then. Good afternoon, guys. We hope that you all tuned in at this stage. Welcome to the webinar. Legal costs are far too high. This is the view of the government, the judiciary, and the public. Whilst the perception may be that legal costs are too high, everyday practice indicates the contrary. My experience is that come the end of August every year, many practitioners cannot comply with their trust account audit obligations simply because they cannot afford to appoint an auditor. We are indeed a diminishing profession, earning diminishing fees. Even taking into account new admissions, deaths, and retirements, over the last about 9 years, we've lost approximately 5,000 legal practitioners. The Honourable Deputy Minister of Justice has cautioned the SA Law Reform Commission in formulating their recommendation to government in respect of the new fee structure to put the interests of the public before that of the profession. And that's a golden thread that runs throughout their deliberations. The full list of authorities you'll find on page 75 of your manual, but 3 books which I want to recommend to you specifically are the following: A Taxation of Legal Costs, Taxation of Legal Costs by Francis Subbiah, Subbiah, from Juters, and then Taxation of Costs by Kruger and Mostert, Taxation of Costs by Kruger and Mostert. It's a LexisNexis publication. And then the old granddaddy Cilliers, C-I-L-L-I-E-R-S, Cilliers on Costs by LexisNexis. We're privileged to have here today in our audience a wide spectrum of persons involved in the legal profession. I'll try to address the needs of each group, so please indulge me where I sound too technical or not technical enough. I try and cater for all segments. In the course of the presentation today and tomorrow, we will be addressing theory, Section 35 of the Legal Practice Act, counsel's fees, mainly tomorrow, fee agreements, present and future, cost aspects of contingency fee agreements, the calculation of the allocateur, practical exercises, a number of specific items in regard to the taxing on imposing or bills of costs, legal practice council rules and various court judgments. We will not be addressing Section 65 procedures. Today will be more theory and tomorrow will be more practical. And guys, you're more than welcome to submit your questions as and when you can in terms of the house rules. And we will then try and answer them between 2 and 2:30 this afternoon. We'll have a short break at about 1 o'clock, just to have a break for 5 minutes or so, around about 1 o'clock. You are all part of the legal profession. In whatever capacity that you're listening today, you're all part of the profession. The word profession comes from the Latin word professio, which means worthy of public trust and admiration. And I want to repeat that and accentuate it. Profession comes from the Latin word professio, which means worthy of public trust and admiration. Question, is this relevant for our profession? Indeed so. And the two questions I pose to you hypothetically are the following. Can you be a part-time honest person? Can you be a part-time honorable person? May I suggest not? You are either honest in your entire being or you're not. You're either honorable in your entire being or not. You cannot be honest between 8 and 5 in the day and then dishonest for the rest, and the same with being honorable. And the practice of law requires you to be honest in every facet of your life, as we will amplify later as we go along. Now, all we have to sell is our knowledge, time, and good name. Besides your health and religion, your most important asset you have is your good name. Your good name includes attributes such as honesty, integrity, wisdom, and compassion. Now, having lost your good name, when do you get it back? Some years ago, an attorney who had been struck off the roll applied after 16 years for his readmission. In the intervening 16 years, after being struck off, he led an impeccable life. He became a captain of industry, chairperson of a large public company. And yet the court said no, because the court was not yet, and I quote, satisfied as to his genuine, complete, and permanent reformation of character. Yes, sometimes practitioners are readmitted, but the point I'm making, guys, is that once you lose your good name, it's most difficult to get it back. Giving a lecture some years ago, a young man was asking me questions which I realized he wasn't asking me about the substantive content of the concept. He was trying to get me to demarcate the edge of the cliff. In other words, how close to the edge of the cliff he could go before he fell off. And I asked him, young man, how do you feel about ethics? And he said to me, sir, ethics stands in the way of making money. Now, one can have a giggle about that, but really it's a sad perception of the law. We don't practice law just to make money. Yes, to make money as well, but we do it in an ethical way. Now, the rules pertaining to costs are many and are complex. However, an overriding consideration is that a court always has a discretion to make any order the court deems fair under the circumstances. Now, I would suggest that you have pencil and paper or make some notes, because as we go along, I'll be making some side notes which are not in your manuals, and this may help you as we'll be coming back to these things again. Now, the first note that I suggest you make is the following. A useful definition of the concept of legal costs is to reimburse a successful litigant for fees and disbursements necessarily and properly incurred. I repeat, a legal costs order is to reimburse a successful litigant, for fees and disbursements, necessarily and properly incurred. Now, this definition, which we will revisit on a number of occasions, gives you the parameters and the basic philosophical approach for a cost order. A cost order is not meant to enrich somebody. It's meant, as far as possible, to reimburse a successful litigant for fees and disbursements necessarily and properly incurred. Now, the notes you receive today can be used as a guide, but please note that the tariffs must always be checked because they change from time to time. And please don't just rely upon my opinion. I merely give you my opinion. Always do your own research. The latest substantive amendments to the tariffs of the SCA High Court and Match Court were published on 3 June this year. In other words, just about 5 weeks ago. On 3 June, in Government Gazette number 46475. I repeat, Government Gazette 46475. And these are effective from 8 July 22. So they were published on 3 June, but effective from 8 July 22. Now, just to pause there for the moment, when you draw your bill of costs, where there have been amendments, you have to then stagger your bill of costs. In other words, you will debit a fee as per the tariff applicable on the date the work was done. So in the present case, from 8 July onwards, you will use the new tariff. For work done prior to that, you will use the previous tariff. And the previous tariff was effective from 11 September 2020. So you have to stagger it, but you debit the fee as per the tariff applicable on the date when the work was done. Now, before we analyze Section 35 of the Legal Practitioners Act, we must have regard to some of the recommendations of the SA Law Reform Commission. In this regard, there have been 2 discussion papers, basically, one in October 2020 and one of about 560 pages earlier this year. Now, I merely give you a summary. This will be sent to you later together with a list of authorities. So the authorities that I mentioned today, which are not in your manual, you'll be receiving a copy of that with all the citations, and together with a copy of what I'm about to read out to you now. So pursuant to Section 35(4) of the LP Act, the SA Law Reform Commission has put out certain recommendations, which I'll just summarize for them because, as I say, the 2 together are more than 1,000 pages. I'm going to summarize some of them. To these recommendations, the LSSA has made certain recommendations, in some cases agreed, in some cases disagreed. But here we go. These are the recommendations, and you'll see what direction the SA Law Reform Commission is taking or intending to take in regard to the practice of law in future. Recommendation 2.2a, the court rules and practice directives should be made uniform across all courts. Recommendation 2.2d, an electronic platform should be introduced to obviate physical attendance at court to file documents. I just note what the implications could be of any one of these recommendations. Recommendation 2.3, the lower courts should be strengthened, including having a continuous trial role, not day by day as we have at the moment. As far as possible, the lengths of affidavits and heads of argument should be limited as determined by the heads of court. Now, to this, the LSSA has reacted negatively and not accepted this recommendation. Next, recommendation 2.5, early discovery to be obligatory and alternative dispute resolution to be mandatory. To this, the LSA has said no. 2.8, the current paper-based legal process should be transformed to a digital process. 2.11, any improper or unethical billing practices to be addressed by the LPC. To reduce legal fees, all forms of payment and receipt of referral fees should be an act of misconduct. In other words, the Law Commission is saying that we should not give each other a 1/3 allowance. They believe that would then reduce legal fees. The LSSA says no, they don't believe it will then reduce the fees. Recommendation 2.14, all advertising to be allowed subject to the general advertising law of South Africa. Recommendation 2.17, junior counsel's fees are no longer a percentage of the SILK's fees, are limited to his or her normal fee. In other words, it will be a deviation from the present existing normally 1/3 junior fee of the senior's fees. Recommendation 2.18, an attorney need no longer be present when a matter is argued by counsel, provided the client is satisfied that someone will be in court to instruct counsel. This is apparently to assist the state attorney to alleviate the staff shortages. To this, the LSSA has said no, they don't agree with the recommendation. The LPC should consider the viability of introducing community service by post-study law graduates. 3.6, the jurisdiction of the small claims court should be increased to 40,000 Rand. And guys, please bear in mind, these are only recommendations, they have not yet been implemented. 5.2, the court should be encouraged to set a lower amount in contingency fee agreements, taking into account what may be a reasonable fee considering the risk factor. Again, to this, the LSSA has not agreed to the recommendation. In other words, what they envisage here is a deviation from the 25% or double the normal fee, whichever is lower in contingency fee agreement situations. And then something that goes along with it is recommendation 6.2. A court should consider applying the proportionality test in addition to that of reasonableness when awarding costs. In other words, they say weigh up the effect of costs against the capital recovered. In other words, if you have, let's say, 100,000 Rand capital, you can't have cost of 200,000 Rand. There should be some proportionality. 6.4, the LPC should consider developing a fee guidelines in regard to pre-litigation costs for lower income clients. This would affect specifically RAF cases. Recommendation 6.5b, fees charged by experts should be regulated by the relevant professional bodies. In other words, what the Commission envisages here is that the council for the medical council, the architects and whatever else, any other experts, that those bodies should be mandated and obliged to regulate the fees of the experts who appear before courts. 6.6, there should be an investigation to consider establishing a code of conduct for legal cost consultants. At the moment, there is no such a code. We'll be talking a lot today and tomorrow about cost consultants, but the recommendation is that there should be some code for their behavior. The tariffs of attorneys and counsel in all courts must be reviewed and contained in fee guidelines. That's recommendation 6.7. So what they envisage is that there will be fee guidelines subject to certain conditions for all courts, for attorneys and counsel. 7.3, the LPC should develop service-based attorney and client fee guidelines in respect of all branches of the law. 8.1, corporate clients in the upper income band and high net worth individuals should be excluded from the protection of the mechanism for determining legal fees. Now, I just want to stop there for the moment. Will this require you to ask your client for a statement of assets and liabilities or income and expenditure? How do you then determine whether your client is in the upper income band and high net worth individual? Interesting recommendation. Guys, I'd like you to then turn to section 35, which I believe is on page 12 of your manual. There we go, page 12. And I'd like you to read with me, because we will stop and discuss certain things. We'll start from subsection 7. Subsection 7. Now, I emphasize that these subsections have not yet come into operation. We believe that it's imminent, but at the moment, they're merely guidelines, but they will be implemented shortly. So at this stage, we're talking pre the promulgation of or the operation of these subsections. But these are paramount because this is the genesis of all of the mandate between attorney and client, and also an advocate, a trust advocate. And by the way, guys, when I talk about advocate in this sense, I include only the trust advocates. So sub 7, when an attorney or advocate first receives instructions from a client rendering litigious or non-litigious legal services, as soon as possible thereafter, the attorney or advocate must, so it's peremptory, you have no choice, you must provide the client with a cost estimate notice in writing, specifying all particulars relating to the envisaged costs of the legal services, including the following: the likely financial implications, the attorney advocate hourly fee rate, an outline of the work to be done, the likelihood of engaging an advocate, if the matter involves litigation, the legal and financial consequences of the client's withdrawal. Now, this includes probably also arbitration and possibly mediation, if mediation is resorted to in future. So this is an imperative. You have to, for every mandate that you get, you have to have a written quotation. Of course, with volume matters, high volume matters, you can then have a schedule encompassing those cases, but you have to have a written mandate complying with these requirements for every mandate that you get. Sub 8, any attorney or advocate, in addition to providing the client with written statement, must also verbally explain every aspect. So sub 7 gives you the obligation to give a written quotation. Sub 8 obliges you to verbally explain every aspect. Sub 9, a client must in writing agree to the envisaged legal services by that attorney or advocate and incurring of the estimated costs as set out in the quotation. So the client must now accept in writing your written mandate as verbally explained. Sub 10, non-compliance by an attorney or advocate with the provisions constitutes misconduct. In other words, it's unprofessional. And non-compliance will see you being invited to the LPC with no tea or coffee provided. 11, if any attorney or advocate does not comply with the provisions of this section, the client is not required to pay any legal costs to that attorney or advocate until the counsel has reviewed the matter and made a determination regarding the amounts to be paid. Now, guys, understand the implication of this. This is consumer protection par excellence. Now, I can envisage, having been in practice for many years, that unless you comply with these particulars, sub 7 to 11, meticulously, you will get a client who will say, oh no, but the attorney didn't verbally explain some aspect to me, because in terms of sub 7, you must explain every aspect, and it's not beyond imagination that the client will say, oh no, but you didn't explain that to me, and therefore I refuse to pay, and then I want the counsel to first review the matter. That takes 6 months to 12 months. We don't know the state. In other words, excuse me, a client will delay the payment of this as long as possible. So it's imperative, guys, that you take note of the section 35(7) to 11 and comply meticulously. Now, in terms of subsection 7, a practitioner is required to give the client a cost estimate. This presupposes that you are required to spend time and apply your mind to do your calculations to arrive at a cost estimate. And the question arises as to whether you are entitled to charge your client for this. In terms of section 15 sub 3 of the Consumer Protection Act, the answer is no, unless there's a prior agreement to the contrary. So again, I suggest to you that when you have a mandate from a client, make sure that you then get a consent to charge him or her for the calculations to be done. Now, I suggest that in practice, it is nearly impossible at the commencement of any trial matter or motion matter to anticipate the total costs up to the final adjudication of the matter. And it is therefore recommended that a staggered estimate be given. And as the matter proceeds, further estimates can be given. For example, in a trial matter, the first estimate may be limited to, for example, a consideration of the merits of the matter. If a client wishes to proceed, the second estimate could include the formulation of the summons of POC, the issue and service of the summons and the receipt of the term of service, intention to defend and plea and counterclaim. Subsequent estimates could accommodate the interlocutory applications, further proceedings, pretrial notices, expert witnesses, discovery, and so on. Now, in this regard, I would refer you to page 17 of the handout. Now, what you have on page 17 is a sample long-form litigation cost estimate template. Now, this is merely a suggestion. It was obtained and adapted by Sonia Labuskachny and Etienne Barnard. And it is a suggestion, it's from 17 to page 25. It's a suggestion that you do. Now, I would suggest that before we turn to page 18, on page 17, at the end of the existing paragraph 3, please insert the following. Because of the relevance of the POPI Act, I would suggest that you insert at the end of paragraph 3 the following. And the client consents, to such disclosures, of facts and information, to such parties as may be deemed necessary. I repeat, and the client consents to such disclosures of facts and information to such parties as may be deemed necessary. That will then cover you in terms of the POPI Act. Now, guys, if you turn over the pages to pages 18 and so on, 19 and so, you can stagger it wherever it suits you. My recommendation is do not, at the commencement of the matter, give an estimate to cover the entire matter. You'll come off second best. I would suggest you use pages 17 to 25, and as per your feeling of the case, stagger it as far as you want to. For example, if I go to page 19, the case analysis, development, and case strategy, you could just have that as your first estimation category. Offers of settlement, pre-trial pleadings, have that, your pleadings. Any interim or interlocutory motions or applications, a separate staggering. And so you can stagger it wherever you want to. Going to page 21, your motions, your disbursements, 20, your discovery. The discovery is a very important part of any litigation and is time consuming. Use that as a separate category. And so you can go on. Page 23, pre-trial preparation and trial. Further category, appeals if should be. And then I would suggest on page 25 to insert after paragraphs 1, 2, 3, and 4, insert the following. Why I suggest these insertions, guys, is that to try and thwart those clients who will try and do anything not to pay your fees. You recall I said to you that in terms of section 35 sub 8, you have to explain verbally every aspect, failing which it could be a professional misconduct. So insert the following 5 at the end of the existing 4 on page 25, put in a new paragraph 5 as follows. The legal practitioner has verbally explained every aspect of this cost estimate to my satisfaction. I repeat, the legal practitioner has verbally explained every aspect of this cost estimate to my satisfaction. This may obviate attempts by a client to deny otherwise. Now, guys, on page 26 to 32, you have the same draft, but now for motion proceedings. This one was just a sequestration. But again, stagger it as far as you possibly can and as you like. And please insert on paragraph 3 in the bottom at the end of page 5 again, rather paragraph 5, insert those 2 amendments as well in the motion proceeding matters. All right, guys, now if you go back to the main manual, in the course of this discussion, I'll be referring to various categories or types of costs, but the main division is between litigious and non-litigious costs. And that you get on page 15 of your main bundle. Now we need to spend some time here because this is the important division in the law of costs. And there are 2 branches, the non-litigious costs and litigious costs. And to understand the distinction is different, is important rather, because the 2 of them are totally different and they are subject to different rules. Let's go down the right-hand column first. The litigious costs. Litigious costs are costs arising out of litigation. A sues B. A brings a motion pleading against B. Litigation, trial or motion. Litigious costs arising out of litigation. Now those costs are accommodated in a bill of costs, which we'll be talking about tomorrow. Litigious costs are prescribed by tariff. High court, match court, appeal court, and so on. So they have a tariff. Party and party, you get three types of litigious costs. Party and party, they have a tariff. Attorney and client and attorney-owned client have got no tariffs. I repeat, they've got no tariffs. I will explain to you tomorrow how they are computed. Then they are determined by a taxing master. Now, guys, when we talk about taxation and taxing master, got nothing to do with SARS. In our context, taxation means really an audit, a certification by a taxing master, who is normally a clerk of the court or a registrar, a taxing master at the High Court or the relevant court. Now, a bill of costs is nothing more, nothing less than the following. You have created a file with your trial or your motion. You have done certain work, correspondence, pleadings, applications, whatever else. So you have drawn your bill of costs, as we'll see tomorrow. You've taken your well-kept file, which I'll repeat 20 times between now and tomorrow, with no regret from my side, no apology. You will have your well-drawn, your well-kept file, your correspondence, your pleadings, your consultations, your research, your discovery, whatever else. You will then apply that to the tariff. You will marry your file and the tariff. That becomes your bill of costs. And the taxing master then really, in the legal sense, audits your file to see whether the tariff you charged was correct and whether the work you said was correctly notated. That's a bill of costs and taxation. Let's go back. We start again. Litigious costs arising out of litigation is housed in the bill of costs. There's a prescribed tariff for every court. We have three types of litigious costs: party and party, which have their own scales, tariffs. Attorney and client and own client, they have got no scales. They are determined by the taxation by a taxing master and can be reviewed by a relevant court. If you go to the left-hand side, up top there, the non-litigious costs, you give your client a statement of account, not a bill of costs. It must be itemized. Code 3.8 of our code requires your account faithfully, accurately, and timeously. Accurately means then you can no longer give a lump sum account. For example, you can't just say to work done ABC 10,000 Rand. You have to give details unless it is an agreed fee, unless it's agreed fee. The fees must be agreed or reasonable. In future, they have to be agreed once the Section 35 becomes operative. There are no scales. You have no scales such as you have with the litigious costs. And if your client is unhappy with the amount of the account, it is then assessed by a fees assessment committee of the Legal Practice Council, unless there is some statutory provision, which we'll talk about tomorrow. So normally, any costs which are non-litigious are assessed by the Law Society, unless there's a statutory provision. Now, what is deemed to be non-litigious? Criminal work, all chamber work. For example, drafting deeds of sales, drafting leases, all chamber work. Administrative work, liquor licenses, drafting wills, arbitrations, curatorships, liquor license applications, commercial agreements, Companies Act work, deceased estates. Most tribunals are also deemed to be non-litigious, although some tribunals apply court tariffs. So guys, please, this demarcation of costs on page 15 is very important to understand the whole structure of costs. If we can go to paragraph 1.2 on page 16 of your manual, the balancing of duties. Now, I'm not going to read every paragraph with you. I'll just hopscotch with the important matters. What we have here is the following. There must be a proportionality of costs. You cannot have, for example, a capital of 57,000 Rand, the case I once had, and costs of 118,000 Rand. That's unethical. At some stage, we all have to say to our client, listen, it's not worth your while. Client may say, yes, but it's a principal. Well, then they want to pay for a principal, fine, but guide your client that there must be some proportionality as to the capital involved and the costs. Please bear in mind, you also have an obligation to a non-client. You have an ethical as well as a legal duty towards a non-client. Don't ever ambush a non-client or a client, and always explain to a non-client, especially when he or she is not represented, that what the cost implications are of things. Very important. The economics of an attorney's practice. Now, just mumble with me for the moment, please, the following. We talk about economics of an attorney's practice. We're all business people. We're there to make money. For every 100,000 Rand, sorry, for every 100 Rand income you receive, roughly 62 Rand is in respect of overheads, your salaries, your rentals, whatever else. So every 100 Rand, roughly 62 Rand goes for overheads, leaving 38 Rand. Of this, SARS will take roughly 18 Rand, which leaves your net profit of 20 Rand. In other words, if you have an income of 100 Rand, you'll be taking home 20 Rand. So if you have an income of 1 million Rand, you take home 200,000 Rand. Now, what are the consequences if you fail to debit one letter per day? Let's say that you don't bother, or you slip up, or you don't debit one letter per day. Let's assume that you charge 100 Rand per letter, just for argument's sake. If you forget to debit one letter of 100 Rand per day over a career of 45 years, 20 days per month, times 12 months, times 45 years, just under 1 million Rand. Guys, are you with me? In other words, if I forget to debit 2 letters per day, I'm losing 2 million Rand, and so on. Now, what I'm saying to you here is that all you have to sell is your time and knowledge. Debit it, debit it. I have a very wonderful, dear secretary, been with me for many, many years. I think she debits every breath I take, but that's the way to do it. You're only selling your time and your knowledge. If you want to play Father Christmas and give away time that you don't debit, well, that's up to you. How do you determine your fee structure? How do you know what to charge? Well, you do so by ascertaining your base cost to be adjusted to the clients you serve. In realistic terms, you determine all your projected overheads for the ensuing financial year. In other words, you sit back and say, right, for the year ahead of me, I will need to pay rental so much, salary so much, telephone, equipment, insurance, bank charges, whatever else, audit fees, professional fees, insurance fees, costs of library, whatever else. You take all those costs and divide it by roughly 1,800. Now, 1,800 are normally roughly the billable hours that you will have in a year. So you take your total overheads, as you can project them for the year ahead, divided by roughly 1,800 Rand, and that gives you a very basic cost. To that, you must add your profit margin to cater for your drawings, less all tax thereon. And then you can apportion an hourly rate for your partners, for PAs, CAs, and support staff. And also factor in a percentage for bad debts, because it's unlikely that you will cover all your debited fees. And obviously, for volume-based discounts, you can consider that as well. If we go to 1.4, we've done that, 1.41 mandate. Ascertain precisely what and from whom your mandate is. This is very important, guys. Ascertain precisely what your mandate is and from whom you obtain a mandate. And ask the question, is the person who gives the mandate, is he or she entitled to do so? Especially with company matters, make very sure. I want to point out specifically Code of Conduct, paragraph 18.13, which you please make a note of. This is very important. When can you accept a mandate when a colleague has been on record? In terms of Code of Conduct 18.13, you may not accept a mandate knowing there to be an existing mandate or a freshly terminated mandate without explaining all implications to client, in particular the cost implication. I want to stop there for the moment. In other words, the client comes to you and says, listen, your colleague, I'm going to end his or her mandate, and I want you to take the matter over. You may do so, but only after you have explained to your client what the consequences would be of the previous attorney's lien over the file. Code 18.13.2. In a contingency fee matter where he or she knows or ought to know that there was no good reason for terminating the grant, you may not accept the mandate. I repeat, 18.13.2. In a contingency fee matter where he or she knows or ought to know that there were no good grounds for terminate the existing mandate, you may not accept the mandate. What we're trying to prevent there is the following, is that in many RAF cases, a month before the trial, you who have run the case for 2 or 3 years and incurred all sorts of expenses, find your mandate is terminated, you settle all the costs, and a colleague takes over, and then that gets the money, and you will sit there with debts. 18.13.2, contravene that, it could be unprofessional. Paragraph 1.4.2, taking a deposit. Guys, the more deposits you take, the less bad debts you have. Simple as that. You are not your client's bankers. If you take a deposit for future work, you receive it in a trust account and do a trusted business when the work is done. But I urge you, as far as possible, unless you're doing it pro bono or whatever else, take a deposit. Unless you're working for a large corporation, take a deposit. I point out Code of Conduct 18.1. 18.1 says that you shall refrain from accepting a deposit for a future act or omission forming the basis of a criminal charge. I repeat that. 18.1 that you must refrain from accepting a deposit for a future act or omission forming the basis of a criminal charge. That's a so-called club or lay-by. A client cannot say to you, I will pay you Rand X per month, and one day when I'm charged with a criminal offence, please defend me. You cannot take a deposit in a case like that. Paragraph 1.4.4, the contingency fee agreements. Now, we need to spend some time on this. We will only be dealing with the fees aspect of contingency fees, not the substantive law. As you know that in a contingency fee agreement, or the CFA, you're entitled to 25% of the capital recovered, or double your normal and attorney and client fee, whichever is the lesser. I repeat, when calculating your fees in a CFA situation, you're entitled to 25% of the capital recovered, or your normal attorney and client fee, whichever is the lesser. Now, in other words, you would normally draft a attorney and client bill of costs, which we'll talk about tomorrow as well, and then double it to ascertain your normal fee. Where the practitioner is VAT registered, the question arises as to the computation of VAT. Now, Rule 70 in brackets 3 in brackets capital A of the Supreme Court Act and Rule 33 sub 23 of the Magistrates Courts Act allows for VAT to be added to all costs, fees, disbursements, and tariffs, in respect of which VAT is chargeable. Now, we'll just stop there for the moment. How do you compute your VAT on your legal fees? Now, we must distinguish between what is legal fees and what is the so-called uplift or success fee. The Act says that you are obliged to charge VAT on your legal fees, all right? But now, your success portion or uplift portion is not a legal fee, it's a reward. So in calculating how you charge VAT in regard to CFA matters, you're required to distinguish between what the legal fees are, the fees for the legal services, and what amount represents the success or uplift fee. Now, at this stage, we can say the following. In regard to VAT on legal fees, you're obliged to debit VAT fees, and you may charge your client. In regard to the success portion, you're still obliged to account it to SARS for the VAT, but you may not charge your client. Now, we'll try and unpack that. In the case of Masangu versus the RAF, in your bundle, it was held that a VAT registered practitioner is obliged to raise VAT on the legal fees portion and may debit the client for the VAT, but in regard to the success portion, the practitioner may not charge the client for VAT, although he or she must account to SARS for VAT on both component parts. I want to repeat that because this is important. In Masangu, it was held that a VAT registered practitioner is obliged to raise VAT on the legal fees portion and may debit the client for the VAT. But in regard to the success portion, the uplift portion, the practitioner may not charge the client for VAT, although he or she must account to SARS on both component parts. In other words, VAT on the legal fees are exclusive, whilst VAT on the success portion are inclusive. Now, as I understand Masangu, the following. A fee is a fee for services rendered and advice given. The success or uplift fee is not a fee for legal services, but a reward. So guys, please distinguish. The VAT portion on fees is one thing. The VAT portion on the success is another thing. In other words, if you're VAT registered, charge your client VAT on the fee portion, exclusive. You may debit your client. You may not charge your client VAT on the success or uplift portion. In both instances, you account to SARS for that. It does not matter if your client is VAT registered. The question is whether you are VAT registered. Now, let's try and give you an indication practically as to how we apply Masangu as I understand it. You may want to make a note of this. Let's say we recover a capital of 1 million rand. So capital recovered is 1 million rand. My normal fee would be 100,000 rand. My double or success fee is a further 100,000 rand. So my total fees are 100,000 rand. My VAT on my normal fee is 15% on that 100,000 rand. That I may charge my client, that's VAT exclusive. On the second 100,000 rand, my success fee, also 15,000 rand, 15%, 15,000 rand, that I may not charge my client VAT for, because it's not a legal service, it's a reward. In both cases, I count to SARS. Let's take a second example. Capital recovery is 1 million rand. My normal fees are 300,000 rand. That's now per my tax bill of costs, attorney client bill of costs, which I'll come to again later. Normal fee, 300,000 rand. My double or success fee is then also 300,000 rand. My total fees are 600,000 rand. But I may not charge that because I must charge double my normal fee or 25%, whichever is the lesser. So I'm limited to 25% of the 1 million rand. So I can only charge VAT on the 250,000 rand. And that is in VAT exclusive. I may charge my client for the full amount. I'll just go over it again, just to make sure that you understand that. In the first instance, capital recovered 1 million rand, normal fee 100,000 rand, double or success fee is a further 100,000 rand, total is in 200,000 rand. So the VAT on my normal fee is 15%, 100,000 rand, that's 15,000 rand. I may charge client that's VAT exclusive. On the success fee portion, 15%, 100,000 rand, I may not charge my client for that. In both cases, I count to SARS. In the second instance, the normal fee is 300,000 rand. Double is a further 300,000 rand, that's 600,000, but because that's more than 25%, I'm limited now to the 25%, which is then less than the normal fee, so I can charge my client the full amount. Now, a normal fee is a total of the taxed bill of costs less disbursements. A normal fee, when we talk about a normal fee or double normal fee, is a total of the tax bill of costs less disbursements. In other words, it includes your fees, your drawing fee, and your attendance fee, and VAT as taxed. This is doubled. The capital is never doubled. The capital is something totally different. You never double that. Next point about CFA, where you have more than one legal practitioner briefed in the matter, the question arises as to the entitlement of each practitioner in regard to the fees, in regard to the 25%. Now, Section 3 sub 2 of the Contingency Fee Act was discussed in Matimba versus Nonkulba, 2019. Matimba, it'll be in your list of authorities, which held that the CF agreement binds all practitioners who signed the CF agreement, i.e. all practitioners who signed the CF agreement share in the CF Act formula. The fees of any correspondent, practitioner or counsel who did not sign the CF agreement will be deemed to be disbursements. Now, this might change in regard to the recommendations of the SA Law Reform Commission, who recommend that it will include all practitioners who are involved in the matter. Guys, we will break for 5 minutes, so just be with us. We'll break for 5 minutes. Thank you. Hi guys, we hope you're all back. I turn now to paragraph 1.4.5, a retainer. A retainer is almost like a deposit, but not entirely a deposit. Retainer. A retainer is buy-in availability. Buy-in availability. Now, if I may explain, let's say you have in the medical field or in copyright field, or any field really, you want to make sure that the attorney practitioner is available, if you're the client, available for you. Because you might, for example, if you have a newspaper, you may want to have an opinion every morning as to whether you can publish a certain article, whether it could be defamatory or not. So you buy the attorney's availability by paying him or her Rand X per month. Now, that amount you can receive into business immediately because you are selling your availability. A deposit, as I said just now, was for future work into trusted company. A retainer money you can then get into your business account. So it normally is a precursor to a long-term arrangement, and you buy the attorney's availability. 1.4.6 agreed fees we have done. 147 interim and final accounting. Now guys, the following: always agree with your client on interim payments. You are not your client's bankers. Have you heard that before? You are not your client's bankers. There's no reason on earth why you should carry and subsidize your client, finance your client for months and months on end while a civil trial drags on and on and on. Take a deposit and give your client an interim account. Rule 54.12 requires you, and is peremptory, in 147 you'll see details of all amounts received, particulars of all disbursements, fees and other charges charged or raised, the amounts due to or by the client, and you retain a copy for 5 years. Now you have to give details. Now clients, just in this regard, if you give your client an account, give them a period, 7 days or 14 days or a month, whatever it is, and then require payment. Don't let clients drag on and say they'll pay you next week or next month or whatever else. Unless it's a large corporation who you trust, the ordinary client get your money by way of interim account and the final account. 148, a cost recovery on behalf of client. Costs arising from litigation, from a court order, belongs to a client. So any cost order, the order belongs to the client. The client is litigating party, you are not. So those costs do not belong to you, they belong to a client. The exception is legal aid, which we'll come to later, but any cost order in terms of a court order belongs to a client. Paragraph 1.5. The office administration and costs, guys, on my notes I've marked it here NB, NB, NB. This paragraph 1.5, how you keep your file doesn't concern anybody but you, as long as it is properly kept up, properly collated, in sequence order. As I say, how you do it doesn't matter, but you have to have a properly kept file so that when you come to draw your bill of costs after a year or two, there's no way that you'll remember every telephone call and every consultation unless you made a note of it. With whom, when, what about, duration. Very important. So 1.5 is very important, please. Paragraph 2, we come to ethics. Now, I could regale you for a long time in regard to ethics. People sometimes ask the question, what relevance is ethics to costs? Well, I suggest to say, really important. Let's talk about overreaching. Overreaching means grossly overcharging. Grossly overcharging. And Code of Conduct 18.7 is relevant here. is unprofessional to overcharge your client, and the practitioner bears the onus of justifying reasonableness. So you have to prove that. Now, examples of grossly overcharging. I'm not talking about overcharging by 10 or 20%. I'm talking about grossly overcharging. And two cases that I know of are the following. An attorney charged a client 81,000 Rand for certain work done. When the client complained, when he went before a fees assessment committee and was assessed at 4,000 Rand. So from 81,000 Rand to 4,000 Rand. Now, that person was struck off the roll. Why? That's plain dishonest. It's plain dishonest to do work worth 4,000 Rand for 81,000 Rand charge. Let's say the client had been charged even 6,000 Rand, even up to 8,000 Rand. Okay, can argue with nothing untoward. But 81,000 Rand for work done for 4,000 Rand is plain dishonest. Now, there's an unwritten rule at the laws, legal provincial councils, that where there's dishonesty, you are shown the exit door. Negligence is one thing, but anything smacking of dishonesty, you're then on thin ice. Another case was a client was debited 21,000 Rand, assessed at 2,000 Rand, the attorney was fined 20,000 Rand. So be careful of overreaching, grossly overcharging. Undercharging, 2.2. Now, undercharging can be tantamount to touting or bribery, which in turn can be an offence in terms of Section 3 of the Prevention and Combating of Corruption Act 12 of 2004. Now, bribery can be loosely defined as follows. It's an offence of giving somebody money or something of value to persuade or influence them to do something for you to which you would not normally be entitled to. I repeat, bribery is the offence of giving somebody money or something of value to persuade or influence them to do something for you to which you would normally be entitled to. Now, I'm not going to ask you to tell me how your office functions. But if you give bribes, if you're touting, if you're promising people money to give you work, is that not bribery? I ask the question, is that not bribery? And then the following question, are you then still honorable? Are you honorable if you commit an offense by buying work? Next question, if you're no longer honorable, how can you still be a practitioner? Question, I don't answer. Now, there are various ways of buying instructions. You can give somebody money. There used to be a firm, here I talk about the past tense, there used to be a firm, past tense, in a certain area who on 2 January every year would pay a 1 million Rand check to a large state agency. And the quid pro quo was that they would get all the transfers from that agency for the rest of the year. They would make about 4 million Rand. So the 1 million Rand bribe they paid was a fairly profitable situation. University fees, that a firm pays the university fees for the children of large corporations, CEOs of large corporations, in return for their corporation's work. There used to be a firm that had an arrangement with a state agency that every 3 years, the attorneys would buy them a number of these smart cars, these small little dinky cars on steroids. The attorneys would then pay buy the cars, pay the operational costs, thereby enhancing the agency's profitability. In return, they got all the transfers from the agency. There was a case of a certain practitioner who started, and within 3 months of starting the practice, the practitioner got 9,000 cases, all RAF cases. Coincidental or otherwise. In this regard, I refer you to Code of Conduct 18.10. You may not buy instructions or pay a reward for a referral of work except from another practitioner. This may change if the recommendations of the Law Commission are accepted, but at the moment, you may not buy instructions or pay a reward for work except from practitioner. And then Code of Conduct 18.22, there shall be no touting, do not offer any reward for work. I leave it to you to decide how you practice law. Of course, there's no objection to acceptable marketing, no problem whatsoever. Paragraph 2.3, recovery or attempt recovery for costs for work not done. You shall not charge for work not done, and you shall always debit for work reasonably necessary. You cannot overreach your client by doing extra work. You can't do that. And just a recommendation, only engage counsel if you deem it necessary and if client expressly agrees to counsel being appointed. 2.4, manufacturing costs. Now, what do we mean by manufacturing costs? It does not mean manufacturing tables and chairs. Manufacturing costs means creating costs out of nothing with no factual basis. In other words, you don't do the work, but you charge the fees, or you do 2 hours work and charge for 4 hours. That's dishonest, your manufacturing costs. I want to give you 2 examples. The one is a case of Kekana. It'll be in your list of authorities, Kekana. It's a 1998 SCA case. What happened here was that Mr. Kekana was an advocate doing work for the state attorney, and he was briefed to attend court in the Polokwane, and he gave a debit to the state attorney, but it included certain incorrect statements and certain incorrect debits for work and disbursements not done and not incurred. And he was struck off the roll. And I want to quote for you, and I want to leave you with this thought on this section with the following. In striking off the practitioner, the judge said the following. The practice of law requires absolute personal integrity. I repeat, absolute personal integrity and scrupulous honesty. If you lack these attributes, you'll be struck off. Simple as that. Unless you have absolute personal integrity and scrupulous honesty, if you lack these, you'll be struck off. Now, this is a warning to all of us. Are we perfect? None of us are perfect. We are all sinners. But guys, strive to be honest in every facet of your lives. Go back to the definition we had. Professio, worthy of public trust and admiration. Can people admire you and your firm? The second example I want to give you is a case of the General Counsel of the Bar and Geach, G-E-A-C-H. It's a 2013 SCA case. Now, you might know that in RAF cases, the RAF is very seldom ready for trial. And practitioners know this. So they know that in all probability, unless some miracle happens, the RAF trial will not proceed normally. So they then brief counsel on trial. Now on trial, counsel might charge you, let's say 20,000 Rand for the day. But on postponement, they might charge you 1,000 rand, for example. But they brief counsel on trial, knowing full well that it'll be postponed. What they then do is that you can brief counsel for a number of trials of postponements per day, 5 or 10 or 20 postponements per day, and they can charge you 1,000 rand per time. But they then brief counsel on 10 or 20 times per day on trial, so that the counsel then charges, let's say, 10 times 20,000 rand, not bad for one day's work, knowing that there'll be no trial. That was the situation in Geach, by way of summary, and there were very severe consequences for a number of counsel and later for the attorneys who briefed them. I just want to, as a light moment aside, just give you 2 examples that I've come across in my wanderings in law as to how bills of costs can be manipulated and how you can manufacture costs. And I read now from actual bills of costs. In this case, there was an agreed fee of 4,000 rand per hour. It was a curatorship situation. So the agreed fee was 4,000 rand per hour. But listen to this. Time spent, 2.5 hours, 10,000 rand. Fine. Attend consultation, 30 minutes, 20,000 rand. 30 minutes, 20,000 rand. The next item, attend consultation, half an hour, 20,000 rand. Now, the half hours, which should have been 2,000 rand, became 20,000 rand. So when the attorney was asked, but why do you have 20,000 rand? Oh, said he, but that's a finger error. So we said to him, well, fine, we can understand one finger error, but 12 times finger errors in one bill of costs. On the one page, it was 36,000 rand. In the total, it was almost 500,000 rand that had finger errors. Now, if the other attorney wasn't wide awake, this wouldn't have been picked up. Another one as to how you can manufacture costs. Listen to this. An attorney charges perusing a file, but he must have had a very short memory, because listen to how many times he has to peruse a file. He peruses a file, 3,500 rand. 10 days later, he peruses the file again for 4,500 rand. 9 days later, he peruses the file for 9,000 rand. On the same day, extremely short memory, he peruses the file again for 22,000 rand. 3 days later, 36,000 rand. 43 days later, 4,500. The total perusals was just under 400,000 rand. He was struck off the roll because that is a plain dishonest, and you can't do that. Right, guys, we come to fee sharing. Code of Conduct 12 is relevant here. A legal practitioner may not share professional fees with any person other than another legal practitioner. Candidate attorney and counsel are not regarded as legal practitioners for the purpose of this rule. And I add here, at the moment, neither are trust advocates. The LPC is presently still pondering whether you can share fees with a trust advocate. At the moment, they are saying no. 2.6, we can just skip that. 2.7, failure to render accounts. Code of Conduct 18.18 requires you to render accounts to your client timeously and fully. A large percentage of complaints at the Law Society, the LPC, is a failure to render accounts. Guys, render accounts. 2.8, you have to pay your accounts unless there is a contrary agreement, especially in RAF cases. Advocates must be paid within 97 days of the end of the month in which the account was received, 97 days. We'll talk tomorrow about the payment of advocates' accounts with RAF matters, but this is the general rule. Election Commission, you can read roughly 10% on the amount recovered, but please read those stories there. We come to the case of Bayport Securitization, RA Limited, and the Law Society of South Africa, and Stellenbosch University. Now, what you have here on pages 27 and 28 about Bayport must please be ignored, because what was said here was overturned in the appeal, which I give you now. It was overturned in the matter on 4 November 2021 and reported in the law reports of 2022-2 SA 343 SA. Now, the appeal concerned the construction to be placed on the concept collection costs as defined in section 1 of the NCA, and where the collection costs in section 101 sub 1 sub G, read with section 1035, includes all legal costs and pre and post judgment. It was held no, you are not limited. So I repeat, this portion of Bayport is to be ignored, please. It was overturned on appeal. The appeal concerned the construction to be placed on the concept, the words collection costs as defined in section 1 of the NCA, and whether those costs include all legal costs pre and post judgment. It was held no, you are not limited to that. You can charge extra for that. 2.10 legal aid matters. A cost order in favor of a client is deemed to be ceded to the legal practitioner in terms of section 92 of the Legal Practice Act. I repeat that. A cost order in favor of a client is deemed to be ceded to the legal practitioner in terms of section 92 of the Legal Practice Act. While we're here, what about pro bono matters? There's no provision for costs in pro bono matters being ceded to the client. So this would depend upon your agreement with the client. So where you act for a client in a pro bono matter, make sure you have a clause in there that makes provision for costs to be ceded to you should there be a success. Paragraph 3.2. The LPC and fee dispute committees. As you recall earlier, that we spoke about the fees being assessed, the non-litigious fees being assessed by the fees committee, and then such fees will not be assessed where any state official is empowered to do so, where work is covered by any tariff, and unless the party requesting the assessment pays the fee dispute resolution committee in advance a fee of 5% on the amount which is subject to assessment. Now, in my experience, this normally ends many of the requests for an assessment when a client who is complaining realizes that he or she must pay 5%. Now, 3.3 is very important, guys. In drafting your accounts for non-litigious accounts, take these criteria into account, paragraph 3.3. When we, as the fee assessment committees, adjudicate the reasonableness of non-litigious fees, we take these things into account: the amount and importance of the work, the complexity, the skill, labor, specialized knowledge of the matter, the number and importance of the documents, the place where and circumstances in which the services are rendered, the time spent, where money is concerned, the amount thereof, the importance of the work, the quality, I always say also the novelty of the work, the experience or seniority of the member, and so on. So take this into account when drawing an account for non-litigious matters. Paragraph 3.4. We'll do that tomorrow. We will do the actual exercises tomorrow. At this stage, just please bear in mind, in terms of Rule 54.12, you may no longer give a lump sum account. And just in passing, you may not charge for the drafting of a non-litigious account. You may not charge for the drafting of a non-litigious account. Paragraph 3.6. The liability of your client for increased amounts. Let's say that you have given your client an account and your client doesn't agree with it and requests that the matter be assessed by the fees committee. Can you reserve to yourself the right to say to your client, right, I will help you to have the matter placed before a fee committee, but I reserve the right to charge an increased fee if so assessed. You can only do so if you have the wording at the bottom of paragraph 3.6 that on request a tax bill of costs will be appropriate in account of assessment, or the LPC will be furnished in respect of any item. If you have that, you're entitled. This should appear on any invoice given to your client. And the attorney is bound to the account as delivered unless you insert the reservation which I gave you above. We can move on now to paragraph 4.4, somewhere down the page. Now, guys, if you go back to this morning earlier, or this afternoon earlier rather, when we spoke about the main division between litigious and non-litigious costs, going down the right-hand side, we spoke about the different types of litigious costs. So we're now talking about that little block, that the different cost orders, the party and party costs, and so on. Now we're going to address that because this is very important. Party and party costs are costs, charges, and expenses which appear to the taxing master to have been necessary and properly incurred for the attainment of justice or for defending matters. The operative words are necessary and proper or reasonable. So what we have here, party and party costs are those given in any normal cost order as being party and party. So A sues B for Rand X, and the court says, I grant judgment for A for Rand so much and costs. If the order just says and costs, it means party and party costs. And those are the only costs that have a tariff. Party and party costs are the only costs that have a tariff. So there are costs that are necessarily and properly incurred. If there's no tariff item, you cannot charge. If there's no tariff item, you cannot charge. And a question I very often get, what about loading on case lines? They are deemed these days to be attendances. Now, how do you identify a party and party cost? How do you identify an item? For example, telephone call from client to make an appointment, party and party. Attend client on consultation, taking instructions, party and party. Drafting summons and POC, party and party. Attending registrar to issue summons, party and party. Attend sheriff to deliver summons, party and party. To attend sheriff to uplift return of service, party and party. To attend sheriff to pay fees, party and party. Telephone call from client's mother-in-law to inquire about progress, no, attorney and client. Why? There's no definition of party and party costs, but my experience says to me that a party and party costs covers that item that moves the matter forward towards judicial finalization. I repeat, use the test. Does this action that I'm trying to debit now, does it move the matter forward towards finalization? When you attended the registrar to issue summons, that moved the matter forward. When you attended the sheriff to take the summons to him or her, that moved the matter forward. When the mother-in-law phoned, no. Now that's an extreme example, but ask yourself the question. I can't think of all the permutations, but does the matter, is it moved forward by this action? If it does, party and party. If it doesn't, attorney and client. And I repeat that party and party is the only tariff that has a tariff. Then we come to attorney and client costs. Now, attorney and client costs are normally the costs recoverable from your client, or sometimes from the other side. I explain. There are normally two instances when a court would, in a litigation matter, grant attorney and client costs or attorney and own client costs against a litigating party, the loser. I'll give you an example. Let's say A sues B for R1 million, and the court will take into consideration two things before granting attorney and client costs or attorney and own client costs. First of all, is there an underlying agreement between the litigating parties that the losing party will pay attorney and client or own client costs? Let's say you have an agreement of lease or a sale agreement, and there's a clause in that agreement that says that should there be litigation, the losing party undertakes to pay attorney and client or own client costs. In a case like that, the court can then give effect to that and order attorney and client or own client costs. The other eventuality is where a court wishes to express its displeasure with a litigating party. In that case, the court can express its displeasure by granting attorney and client, or in a case of extreme displeasure, attorney and own client costs. Now, what I'm saying now is subject to certain reservations, which we're discussing in a few moments' time. Now, I said to you earlier that attorney and client and own client tariffs don't have tariffs. And in that regard, I refer to the case of Coetzee and another. It's in your bundle of citations, authorities. Coetzee and another versus Salant attorneys. It's a 2013 Gauteng Johannesburg case. Now, the procedure was that where a taxi master was confronted with a court order which said attorney and client or own client, they would take the party and party bill of costs as a point of departure. They would take that tariff as a departure. And then in the case of attorney and client costs, add on a percentage, for example, 20%. And in the case of an attorney own client, add on a further percentage, let's say a further 20%. In other words, party and party, and then up it by 20% for attorney and client, and further 20% for attorney and client. In the Coetzee matter, the court did not accept this formula. Sorry. My apologies. And held then that what the taxi master must then do is take the party and party tariff as a point of departure and then look at the matter fact specifically and ad hoc. In other words, not just a standard multiplicity, but look at the matter from a ad hoc fact specific point of view. How involved, how complex, any other factors, but then to use his or her discretion to up the fee departure from the party and party. So at the moment, we have no tariff for attorney and own client or attorney and client, but it's a fact-specific ad hoc deviation from the party and party. A further question, Can a magistrate's court grant attorney and own client costs? In terms of Section 48 of the Match Court Act, a court may grant costs as between attorney and client, but not own client. But the case of war systems, which is in your list of cases, war systems, Brassey AJ held that where the underlying contract made provision for it, a match court could, despite Section 48, award attorney and client and own client costs. While we're there, I just want to talk about costs on appeal. The case of City of Ekurhuleni and Takulisa Trading. It's a SCA case of 3 June last month. It'll be in your list of authorities. The record was in excess of 2,300 pages. The practice note said that just over 300 pages would be relevant. The judges stated that even 350 pages was an overestimation. And the court ordered then that the Johannesburg and Bloemfontein correspondence, attorneys' correspondence for the appellant who lost the case, could not charge their clients any fees for the entire record. That cost them tens of thousands of rands. So be very careful when you compile a record to make sure that you do it only the relevant documents. 4.4.4, costs de bonus proprius. Now, we spoke about the court indicating its displeasure with a litigant. That's when you can get a cost order against you, attorney and client or own client. A cost de bonus proprius is against the attorney or the practitioner, where the court wishes to express its displeasure with the practitioner, not the litigant. And that's when the practitioner is ordered to pay the cost out of his or her own pocket. Shai Tufula. Paragraph 4.4.5, wasted costs. Wasted costs when you get the following situation. Let's say that you have a case tomorrow, a civil trial tomorrow, and today your client phones you and says, sorry, I have to go to Greece. My father has passed away and I need to go. I can't attend the trial tomorrow. The other side have possibly briefed counsel, have got witnesses, so those costs are wasted. In a case like that, the court can grant wasted costs against your client. 4.4.6, the reserve costs. Very often in an exception matter, the court might grant the order for the exception to uphold it or to not, but then say that the court wants to hear the entire matter before granting costs piecemeal. They can then reserve the cost or order the cost to stand over. Costs in the cause that you normally get in a summary judgment application, where the court will say it grants leave to defend the matter and cost will be in the cause. In other words, whoever wins the main case will then get the cost of those interim applications. The cost of the day, 4.4.8, will be the same as the wasted costs for the day. All costs or tax costs just means party and party costs. 4.4.10, the court can say no order made or no order as to costs. In other case, the court says each will pay its own costs, and then there's no order as to costs. 4.5, guys, read that. I just want to highlight one thing, that in the match court interlocutory application in terms of Rule 33.3 cannot be taxed and executed upon unless the court so orders, whereas in the High Court it can be. In the High Court, any interlocutory application that you have a cost order, you can execute tax immediately, which you cannot do in the match court. 4.6, settlement agreements and payment in court and tenders. Guys, this is very important in regard to costs. Let me explain the following to you. I'll give you an example. Let's say A sues B for R1 million. On 10 January, let's say 10 January of a certain year, A sues B for R1 million. Let's say halfway through in June of that year, B offers 600,000 Rand in settlement plus costs and interest. If A accepts that, fine, end of story. If A does not accept it, the trial continues. And let's say that in November that year, the court grants judgment for 500,000 Rand and costs and interest. Now, how does that then affect the costs? Bear in mind that in the middle of the year, B offered 600,000 Rand. Now, at the end of the year, the court grants judgment for an amount equal to or less than the amount of the offer. Now, that will affect the cost, because what will then happen is the following. B will be liable for the cost from date of the summons to date of the offer. From the date of the offer, the courts will say to A, well, the offer that B made should have been accepted by you. Therefore, from the date that the B made the offer until the judgment, you pay B's costs. In other words, the making of an offer of settlement is very important. I want to talk about the so-called Calder Bank, C-A-L-D-E-R Bank principle. I'll just make a note of this, not in your notes, but just make a note of this. Rule 46 of our rules talks about litigation, offers during litigation. What about offers made before the trial, before the summons issued? Now, Calder Bank is a 1975 All England report matter, where the one party declined a fair offer from the other person pre-trial. Can that affect the costs? Now, this was accepted into our law in 2017, and this is in your citations. D and another versus MEC for health is 2017 5 SA 134 WCC, where the court will take into account offers made prior to the commencement of the legal action. 4.7, the cost of two sets of counsel, two sets of attorneys. The taxi masters are increasingly loath to reward any duplication of work. So be very careful when you have work through a correspondent. The taxi master will tax off, in all likelihood, anything done by way of duplication. Just make a note under paragraph 5.1, please, as a general note. The tariffs of the SCA and Con Court are the same. The Labour Court is the same as the High Court. Labour Court is the same as the High Court. Guys, I just want to remind you, any questions, you're more than welcome to let us have your questions. We'll start answering your questions from 2 o'clock onwards. I continue the Labour Court, Labour Appeal Court. The Labour Appeal Court is the same as the SCA. The Labour Appeal Court is the same as the SCA. The Lands Claims Court has their own tariffs, and where these are silent, the High Court. The Competition Appeal Court tax in accordance with the tariff determined by the court order or by agreement, or the High Court. The Equality Court, as per the tariff where the matter was instituted, i.e. Match Court or High Court. Tax courts, the same as the High Court. Industrial Court is the same as the High Court. (522) Attorney and client costs and attorney-owned client costs against the third party. In other words, let's say our losing party. Now, whatever we said here in our notes must please be put under a question mark. Now, I refer you to the case of Maropa, M for Molly, M-O-R-O-P-A, Maropa, and others versus chemical industries. It'll be in your citation bundle. It's a judgment on 31 July 2020, where this whole question of attorney and own clients vis-a-vis a third party was discussed. Now, before I read a few sentences from the Maropa case, to sum up, I can say to you, the legal position appears to be uncertain as to whether a court can still grant an attorney and own client against a losing third party. And why I say that was, in the case of Thoroughbred Breeders Association, paragraph 89 of the Maropa case, Judge Valley refers to the SCA case of Thoroughbred Breeders Association, where it was held that the court could grant an attorney own client cost order against a third party. So that was done in the positive. But the court said there that it was merely a peripheral remark by the court, and this remains yet another issue for future consideration by this court. So the SCA, without considering the matter, granted attorney own client costs against a third party. Judge Valley, after looking at certain certain authorities in the Maropa case, said, on this analysis, I hold that attorney own client scale of costs against a third party is not part of our law. So he answered the question negatively. But he went on to say that, again, this is peripheral and that this should be argued fully at a later date. So you have two conflicting reports, one by the SCA saying yes, but saying that it was a peripheral matter, and the Maropa matter, again, saying it's peripheral, but Judge Valley said he did not apply it. So my advice to you is to continue asking for attorney own client against third parties, and at some stage it'll receive the attention fully by the SCA. At the moment, I would think the balance of probability rests with the SCA, which did allow attorney own client costs against a third party. Makes the law interesting, doesn't it? We come to bills of costs, chapter 6. And guys, may I please request that tomorrow you have a pencil and paper or pen and paper, because we will be doing exercises and you'll be required to do certain calculations. So have a calculator with you, please, and about 10 pages of writing or computer, whatever you want to do it, to go through it with me, please. Now, paragraph 6.1, the importance of drawing good bills of costs. Guys, that's where you win. That's where you win or lose money. Properly drawn bills of costs. That is when you'll find out whether your secretary debited every breath you took or not. Did you debit every letter that you did, every telephone call, consultations, your research work, your pleadings? Is it all notated because of your properly kept file? You've heard that before. You'll hear it again. Keep your files properly. Now, the requisites for drawing a bill, you can just read 621, nothing strange there. Just please make sure you do it correctly. 623, deciding on the applicable scale and tariff scale. When you start drawing a bill, determine, are you drawing a party and party bill, or did the court grant some other order, for example, attorney and client, or even own client? And very important, when you come to draw a bill, go through your file. Were any costs reserved by the court? If so, those reserved costs must first be argued before you draw your bill. So make sure that you cover all those things. Now, 624, I won't stress that too much. 625 is the same. And 63. Now, you should have 6 columns in your bill of costs. And please make a side note on that. I want to change the sequence that you have in 6311. The first vertical column is item number. 1, 2, or 3, because you might have bills with hundreds of item numbers, and you want to identify them as item number 87 so on. So the first column that you have, a vertical column, is item number so and so. The second column is date. The third column is description. That'll be attending client, drafting summons, attending witness, attending court, as a case, description. The next column is number. That'll be pages or hours or folios, number. And then you have your fees. And then you'll have your disbursements. Now, disbursements that you will see in 6318 are council's fees, sheriff's fees, all your outgoings. If you have a Gauteng train trip, if you have a petrol expense, anything that you have to pay out is a disbursement. So you have your 6 columns: item number, date, description, number, pages or times or hours, fees, and disbursements. A word about 6319, witness fees. You get 2 types of witness fees: an ordinary factual witness who saw the collision, or you get an expert witness. My advice is always get a court order mandating the debiting of expert witness fees or any witness fees. It makes it so much easier to prevent an argument with the taxi master. Right, now tomorrow we will start with the à la carte tour, which is a science of its own. Guys, my watch is 1 to 2, so we'll now have a 2 or 3 minute break just to get all your questions, and I'll try and answer them. Right, here we go. And you're more than welcome to submit your further questions. First question from a guest. You please tell me the case name is again or the matter where they explained VAT and CF agreements. Masangu. Excuse me. It's a case of Masangu, M-A-S-A-N-G-O. That'll be in your list of cases. And next, what is the approach to costs after a failed mediation process in terms of Uniform Rule 41A? I believe that is the normal non-litigious fees. Because there was no, I assume that there was no litigation pending in this stage of failed mediation. If there was litigation, then of course it becomes then litigious. Next question. Would 2.10, page 29, include university law clinics where reference is made to legal aid? No, guys, it has to be a formal instruction from legal aid. Or should the session clause in the cost agreement can't cover costs? Yes, unless it's formally from the legal aid, then your pro bono or non-formal or rather informal legal aid then be covered by your cost, your agreement with client. Next question, how would a bill of costs differ of that an attorney who is tried to counsel in a high court trial and that of a trust advocate? Sorry, I've developed a cough now, sorry. I repeat, how would a bill of costs differ of that of an attorney who instructed counsel in a high court trial, that of a trust advocate who did all the work? It shouldn't differ. If the trust advocate does the work, it'll be the same as a same fee structure as that of an attorney. In practice, how are the rule cost limited? How can you use this when opposing a BRC regard to Rule 43? As far as I recall, Rule 43 always had a limitation. I think the limitation has been lifted somewhat, but there are specific rules in regard to Rule 43. There was normally formally a strict limitation. I think that's now been lifted. I think that covers that question, yes. Could you kindly repeat when will the VAT be inclusive and exclusive in a consent agreement? I didn't get it. All right, let me just give it again. You charge your VAT on the legal fees portion and not on the reward portion. You charge a VAT on your legal fees portion, not your VAT portion. Give me a moment, I'll go back to the example I gave you. That's the case of Masangu. And just to repeat it for you, I said to you that if you recover 1 million rand, your normal fee then, let's say, is 100,000 rand. Double or success fee is 100,000 rand. So your total fees are 200,000 rand. Now it's important here that your double your normal fees are then less than 25%. So you have that distinction. So on your normal fee, you will have 15%, 100,000 rand. There you must charge that and you may charge your client. On the success portion, you charge that, but not against your client. You have to debit yourself, basically. You have to account it's inclusive. So on the normal fee, on the fee portion, it's exclusive, and on the success portion, it is inclusive. I hope that covers your question. Look at the Masangu case, you'll find it there. Kindly advise on the step we have served the BOC and the other side has only given us a notice to oppose the taxation with no list of objections. Guys, I'll do that tomorrow, but when there's no list of objections, then they cannot raise objections. In terms of the present rules, you have to give a list of your objections, otherwise you can't raise them, but we'll do that tomorrow. Hi, please repeat the appropriate clause, which you mentioned earlier in the webinar for the estimate template. Many thanks. All right, let me just go to it, give it to you again. under paragraph 3 of the sample long form, you'll say the following. After the words will be prepared, or will be appointed on this basis, you say, and the client consents, to such disclosures of facts and information to such parties as may be deemed necessary. I repeat, and the client consents to such disclosures of facts and information to such parties as may be deemed necessary. Right, there's what we have at the moment. We'll break for 2 minutes to get further questions. Right, further question. Sorry, I missed the answer to this as I was away for a minute. Would you mind repeating, please? Question, when you are presenting a bill at taxation and there's more than one party opposing the bill, how does the taxation proceed? Does each opposing side present their objection to the item first, and then your counter argue defend? Or does one present the objection and you counter that first, and then the next present the objection and you counter it respectively? Shelley, we will do that tomorrow, but I can answer at this stage the following. Let's say that you acting for the plaintiff and there are two defendants, and the court granted judgment against two defendants jointly and separately. So you will present one bill to the two defendants. They can each oppose it, giving their own reasons for the objections. You will present your bill and you will defend your bill, you will motivate your bill, and each one will then give their objections, first the first defendant and the second defendant, and you can then reply to it. It works basically the same basis as a civil trial. That's how it works. And then Shelley also asks, with regard to the limitation on Rule 43 being discontinued, which documentation? That's concerning the rule itself. That's contained. I'll check tonight and answer tomorrow as well, but I think that's, the rule was amended to lift that limitation. Guys, you're welcome. Any further questions? We'll break for a further 2 minutes to get further questions. Guys, at the moment we have no further questions, but again, I invite you, please, later today and tomorrow, let us have your questions. We can then answer them tomorrow. So we'll then meet tomorrow at 12 o'clock. Thank you, and we're off.